Good afternoon, everyone. Welcome to the launch event of the Rule of Law Frequently Asked Questions, organized by Democracy Reporting International and Committee Meijers. I'm Jakub Jaraczewski, Research Coordinator at Democracy Reporting International, and I will be moderating our meeting, which will run for about an hour. And I would like to begin with introducing us and introducing our tool, which we will be talking about today. And then I will introduce our fantastic guests and turn over the microphone to them for elaborate. So today's event is organized by Democracy Reporting International, a Berlin-based NGO working on democracy, rule of law, and human rights worldwide. But in this particular context, we are active since 2019 in a program focused on the rule of law in the European Union. The program is called Reconstitution, and it's being implemented by us jointly with Forum Transregionale Studien under funding from Stiftung Mercator. As part of this program, we engage with journalists, policymakers, and experts towards informing the public debate on the rule of law and providing analysis and expertise on complex topics that we are facing in the area of the rule of law in the European Union currently. This particular project within that program, the Rule of Law Frequently Asked Questions, is a joint initiative of us and Committee Meijers. Committee Meijers is the standing committee of experts on international migration, refugee, and criminal law based in the Netherlands. They are a unique group of law professors, legal researchers, judges, and attorneys working to ensure that the European legislation respects the rule of law and guarantees fundamental rights for anyone. Together, they work to assess EU legislative proposals in areas of criminal law, migration, and constitutional law from the perspective of the rule of law and fundamental rights. And together with Committee Meijers, we've teamed up to bring you the Rule of Law Frequently Asked Questions. This project has been worked on by a large group of people, but I will make a small shout out to two persons that are not with us today speaking, who were particularly heavily involved in this project. One of them is someone whom many of you may know, and that is John Moraine, Professor John Moraine, member of the Committee Meijers, and a man that wears many hats. Unfortunately, one of the hats he is wearing prevents him from joining us today. And the second person which I wanted to mention is our DRI's research officer, Nina Zreteli, who's been absolutely instrumental in bringing this project together and making it happen. Without further ado, let me introduce our speakers for today, and I'm joined by three absolutely fantastic people active in the area of the rule of law who come from very different backgrounds. First joining us is Daniel Freund, MAP for the Greens, a friend of the rule of law not just by his name. Daniel hails from Germany and is one of the most active MAPs when it comes to common shared values of the European Union and the rule of law in particular. Not only is he a very active Twitterati, frequently speaking up on topics related to the rule of law, but he also works heavily behind the scenes. He's been on the Rule of Law Conditionality Mechanism negotiation team and is very active in the European Parliament's works on the rule of law and the work of the Libby Committee, and is definitely one of the people who in the European Parliament keeps the rule of law very close to his heart. Following Daniel, who is going to talk a little bit to us about the information about the rule of law and how the rule of law is being discussed in his work as a MAP, I'm going to turn over the mic to Katalin Halmai, journalist from the Hungarian newspaper Nepszava. Katalin has been in Brussels for over 20 years, if I am not mistaken. She has seen the expansion of the European Union to encompass the member states from Central and Eastern Europe, Malta and Cyprus, and all the subsequent events. And she has seen those countries take their first steps in the European Union, but she also witnessed firsthand the escalating rule of law crisis present in Hungary and Poland, as well as issues present in other EU member states. And she has had in her work a large share talking to people who, for various reasons, support the positions of the Hungarian and Polish government. And she has had much experience with how the rule of law is being framed by those who claim to be reforming or strengthening it, while at the same time are in fact taking actions that amount to backsliding of the rule of law. And our third speaker for today, a very special speaker because he will be the one to introduce the rule of law frequently asked questions and talk a little bit about where the project came from and how do we see it being used and moving it forward, will be Professor Kees Groenendijk, Emeritus Professor at the University in Nijmegen, a founder of the Center for Migration Law at the university, and also, of course, a member of the Meijers Committee, who's been working very closely with us to shape the rule of law frequently asked questions and to ensure that they strike a balance between expert knowledge and accessible format. So, Daniel, Katalin, and Kees, thank you very much for joining us today and for agreeing to participate in our event. And I'm going now to turn over the microphone to Daniel to talk a little bit about his perspective on how to present and discuss the rule of law.
Thanks, Jakobs. Thanks so much for the invitation, and thanks to you guys for drawing up this FAQ. I think it's very timely. I would have wished in many of the conversations I have had over the past years that this had already existed. Then I could have just pointed all those journalists, citizens, whatever, to this FAQ and said, look, read this, and you get all those answers already here in this document, because many of the questions that you guys have answered in this FAQ, I have been discussing pretty much on a daily basis over the past few years. You know, what is the rule of law exactly, and is it true what the governments, for example, in Poland and Hungary say, that they have their own culture of the rule of law, that in any case the EU has no competence over how a member state organizes its judiciary and so on? I mean, all these questions come up. The governments in Poland and Hungary cast doubt and try to impose their bizarre narrative of having somehow a different rule of law that they adhere to than the rest of the European Union or the court, the European Court of Justice. So, well, all this, of course, comes in a situation where we have a crisis of the rule of law in the European Union in several member states, a threat to the union like we have rarely seen it. I mean, the way that the legal order of the union is put into question, both in Hungary and Poland, is really so severe. You know, we have, in the whole 60-70-year history of the European Union, we have never seen anything quite like this. And unfortunately, the European Commission and the member states haven't really been doing anything about it. I mean, Article 7 procedures have been launched against both member states, but we know, you know, for years now that they're not going anywhere because they protect each other. And all the other tools that were there, infringements, the financial regulation of the union and so on, none of that was able to halt the rule of law backsliding in those countries. I was, as you said, one of those that negotiated the newest tool in the toolbox, the rule of law conditionality, which we've had now for almost 15 months, but it's not being used. And it looks as if the situation in Ukraine, Russia's invasion of Ukraine, is providing the latest excuse in a long line of excuses why at the moment is just not the right time to do something about the autocrats inside the union. And I think, you know, it's such a terrible signal to send to all those Ukrainians. You know, for the first time in the history of the European Union, you have people fighting for, taking up arms for a possibility of joining the European Union. I mean, all the member states that have joined, none of the 27 had to take up arms. And that is what the Ukrainians are doing. And let's be frank about this. This is about EU membership, right? It is about what that means, about the westward integration of Ukraine, about the right to self-determination for the Ukrainian people. All this is put into question by Putin. That is why he is invading the country, because he's afraid of democracy, he's afraid of the rule of law, and about that functioning in a neighboring country. So I think in a situation where Ukrainians are fighting for the rule of law and democracy and EU membership, the signal that we send is that we do not tolerate those that basically follow the Putin playbook on the inside and do the same crackdowns on the independence of the judiciary, on independent media, where we have in Hungary in particular, corruption is developing in a very similar way as in Putin's Russia. You see lots of little similarities, I mean, Orban with the stadium in Felshut basically feels like Abramovich and Chelsea, right? So we need to do something about this. We cannot tolerate that exists inside the European Union, and it's high time that the Commission, that the member states take this threat more seriously and crack down. So again, very thankful to you guys for your work and for this FAQ that I hope will inform this debate, because there's still too many, that fall for one or the other argument that the Polish or Hungarian governments put forward. And I think this FAQ can help in answering some of those questions.
Thank you very much, Daniel. And before I turn over the mic to Katalin, I'm going to remind everyone that we will be having a Q&A session after all our guests will be done speaking. And we encourage you to use the question and answer tool in Zoom found on the bottom to send over your questions that we will then ask to our guests. And so I'm going to turn over the microphone to Katalin.
Yes, thank you very much for the invitation, and I am very honored to be part of this distinguished panel. As I am a journalist, I used to ask questions, not giving answers, but I will try my best. This document is really useful as we often come across these myths of daily work as journalists. One of the most frequently voiced arguments of the Hungarian government and Fidesz party is that the concept of the rule of law is not clear and it is not clearly defined. On what basis are we being held to account, they ask, but otherwise they say Hungary fully respects the rule of law, so they must have some ideas about that. Their other argument is that a double standard is applied to Hungary because many elements of the judicial system or of the media landscape or of the system of the public procurement that are being criticized by the EU and international organizations are the same or similar in other member states. While this may be true, many point out that Hungary and also Poland are facing systemic problems. And that is the whole picture, not just the individual elements that need to be assessed. This FAQ not only corrects the false claims of the state institutions, but also points out systemic flaws. It is particularly important to debunk myths about the justice system, because this is an area where journalists who are not legally trained find it difficult to navigate. It is easy to blame the German Constitutional Court for saying the same thing as the Polish one, if you don't get to the bottom of things. Or it is easy to say that the executive branch is interfering in the appointment of judges everywhere, if you don't see the significant differences between member states. It is very important that this document clarifies the differences between the rule of law, democracy, and human rights, because there is a lot of confusion about the two. Take the rule of law conditionality mechanism Daniel just talked about. For ordinary people and also for some journalists, it is still difficult to understand what kind of breaches of law or rights could lead to the EU to withdraw the financial support from member states. Is it possible to activate the mechanism if a critical newspaper or radio station is silenced after a following decision by the state authorities? Or can the violation of minority rights lead to financial sanctions under this mechanism? Can sanctions be imposed for violations of press freedom or human rights? These are the questions we come across very often. While I acknowledge the very important job the Meijers Committee and Democracy Reporting International did by complying this FAQ, I must say that there are institutions whose job, in my opinion, would be exactly to debunk these myths. These are the European institutions, as the populist criticism are also directed against them. In most cases, however, neither the Commission nor the Council is willing to correct the disinformation. Yet both have a duty to do so. The European Commission, as guardian of the treaties, has a duty to publicly refute the lies that are being told about the EU law, EU treaties, or the institution itself. But whenever we ask for a reaction to blatant lies or misleading information spread by one EU member state or another, the answer is always no comment. However, there is a good exemption. In April 2017, the Commission made an exception and replied in detail to the national consultation launched by the Hungarian government and entitled Stop Brussels. The European Commission published its responses to the 6 false claims the Orban government distributed about Brussels, wanting to force Hungary to let in illegal migrants, and Brussels attacking the government's job-creating measures and its tax policies. This was a successful campaign by the Commission, and it is a pity that it is not continuing this way. And a few words about the Council, which for its own sake should do the same and debunk the lies about the Article 7 procedure, for example. But the Council is even more cautious than the Commission, and the exchanges, views, and hearings are held behind closed doors. What we know, however, is that the Hungarian government is always very well prepared and doesn't spare any effort to mention that the situation in other member states is the same or even worse than in Hungary. But we do not know whether these myths are addressed by the others or not. And finally, I would like to mention a Hungarian initiative supported by the French news agency AFP and the European Commission, a fact-checking site called Lakmus, which started operating in Hungary in January this year within a very popular news portal. Its aim is to check the information that reaches the general public and can have a significant impact on their lives. This is a very good project that has been set up with international support. So thanks again for your work. And if you want to follow this, I'm ready to share with you many other myths and lies manufactured by the Hungarian government and politicians. Thank you very much.
Thank you very much, Katalin. I can imagine that in your long career working in Brussels and dealing with subsequent Hungarian governments, you've seen and heard things which probably would be rather difficult to reconcile with what we think the rule of law is and how it should be described. So now I'm going to turn the microphone over to our last speaker today. Kees, if you would be so kind to introduce the rule of law frequently asked questions and talk a little bit about where we came from with this project, where we are, and where we want to go next.
Thank you, Jacob. The current war in Ukraine is a terrible illustration of what happens when political leaders are no longer controlled by democratic institutions, by free and diverse media, by freedom of expression for everyone, by a strong, freely elected parliament, and by independent courts. In the 20th century, Europe learned what happens when political leaders succeed in gradually abolishing these central institutions of a liberal democracy. Leaders turn into dictators. That lesson came at a high price in Germany, in Russia, in Ukraine, in Poland, in Hungary, and all other countries of Europe. That is why the European project after 1945 aimed at avoiding war by close economic cooperation and support for democracy, human rights, and the rule of law. That is why core values are enshrined in the EU treaties and why they are a condition for becoming a member state of the EU. That is why the rule of law has to be upheld as a crucial element of liberal democracy. The Meijers Committee, of which I am a member, is a group of independent academics, judges, and attorneys working already 30 years to ensure that the EU and European legislation respects the rule of law and guarantee fundamental rights for everyone. The committee was established in 1990 at a time when the 5 original Schengen states, Germany, France, and the 3 Benelux countries, were negotiating detailed rules on borders, visa, migration, refugees, police cooperation, and criminal law behind closed doors outside the EU institutions, without control by national parliaments and the European Parliament, without democratic transparency and public debate. The 5 original Schengen states explicitly excluded control by the EU Court of Justice. In our eyes, this was a serious attack on the rule of law within the EU in areas concerning the core of citizens' rights. It took 2 decades before full competence for the EU Court of Justice in these fields was established. The Meijers Committee has a record of acting in support of the rule of law in the EU. In recent years, we published notes on the various legal and non-legal instruments of the EU to protect the rule of law in member states. A few months ago, we published an extensive note on the EU instruments to protect and support media pluralism in member states. On our website, we update a dashboard on the judgments and the pending rule of law cases before the 2 European courts, the one in Luxembourg and the one in Strasbourg. Today we present a new instrument to counter the rule of law backsliding in some EU member states. A set of cards with short refutations of the main arguments used by politicians of government parties in Poland and Hungary to justify their attacks on the rule of law, the independence of the judiciary or media pluralism, or used to defend these policies against criticism from other member states. This set of 25 cards, the rule of law frequently asked questions, was produced in close cooperation by our committee with Democracy Reporting International. Our common idea to debunk myths about the rule of law in Europe was triggered by the observation that the ministers of justice of Poland and Hungary, in interviews and statements, repeatedly used the same misrepresentation of EU law and incorrect statements about independence of judiciary or the separation of powers in other member states, claiming that the rule of law is only a vague concept or a political tool used to target them and their political agendas without justification. Often, These claims are full of myths, of half-truths that hinder constructive debate around the rule of law in the EU. The aim of this set of cards is to assist politicians, journalists, and other actors involved in the rule of law debate to prepare themselves for the discussions and interviews by getting the facts straight and be able to bust the myths built around the rule of law in the EU. In order to reach citizens in member states, the cards are published in 5 EU languages: English, French, German, Polish, and Hungarian. The first 10 cards deal with basic questions about the rule of law, such as what is meant by the rule of law, why is the rule of law important for the EU? Part of our answer there is when citizens move to live, work, or study elsewhere, or when European businesses invest in other member states, they must be sure they can rely on the EU law being applied the same way and that their human rights are respected in other member states. Other questions we deal with is, what is the relationship between the rule of law, democracy, and human rights? The thrust of our answer there is, without the rule of law, which requires impartial and independent courts, human rights and the limits of political power in a democracy are empty promises. Another question often raised by Polish or Hungarian politicians is, can the EU criticize how the member states organize their judiciaries, considering the variety of accepted systems within the EU? How judges are appointed, promoted, disciplined, indeed varies considerably among member states. But the EU treaty lays down a minimum standard by obliging member states to provide effective legal protection to citizens, private organizations, and businesses through independent national courts. The question on yet another card is, isn't it the executive branch regularly involved in the appointment of judges in EU member states? We reply, it's common for the executive branch to be involved in judicial appointments, but it does not never decide alone. The executive typically shares powers with independent judicial councils or appointment boards, together with other guarantees precluding politicians from unduly influencing the appointment of judges. The other 15 cards deal with specific questions and arguments made by governments of Poland and Hungary. For example, haven't Hungary and Poland always complied with the judgments of the EU Court of Justice? The short answer is no. Both governments refused to comply with various decisions of the EU Court of Justice concerning the rule of law in their country. Or didn't the judicial reforms in Poland help root out communist area judges? Our answer is the PiS government has not been able to identify a single case of an active judge who compromised the principles of judicial ethics in communist times. Several of the 15 cards in the second section of our set deal with arguments along the line of other member states are not perfect either, so why criticize only Poland and Hungary? One example of such argument is the EU Court of Justice found that Germany's prosecutors aren't independent either. Our answer there is, after the relevant Luxembourg judgment, the power to issue European arrest warrants in Germany was shifted from public prosecutors to judges. The judgment in Luxembourg also triggered a broader reform discussion on the independence of prosecutors, both under the former center-right and the current center-left German government. This illustrates the authority of the EU Court of Justice and a commitment to change laws and practices in line with the Luxembourg case law, irrespective of the political composition of the government. On the last card, the idea that the EU has no competence to deal with reforms in the national media landscape in Hungary and Poland is in great detail refuted. At a time when we see war at our continent, where an authoritarian regime attacks a democracy, we are reminded of the value of liberal democracy and the value of liberal democracies supporting and assisting each other. The EU was set up precisely to make backsliding less likely, because only countries with a functional rule of law system can and will be reliable partners to one another. It would be a mistake, therefore, to view the EU internal rule of law discussion as secondary at this moment. Issues such as separation of power, judicial independence, and human rights protection to each member state are preconditions for the EU as a whole to function well, both internally and towards its common neighbors. We hope that the set of cards we are presenting today will help journalists, members of parliament, policymakers, and citizens in preparing for the essential debate on the rule of law in and between EU member states in the years to come. Thank you for your attention.
Thank you very much, Kees. I would like to remind everyone that, first of all, our question and answer session is going to begin in a moment, and we are very happy to take your questions. Second, we have put in the chat the link to the Rule of Law Frequently Asked Questions, and there you can download the card and detail a little bit about the background of the project. Now, I would like to start our question and answers session with one reflection that I have, and one which we probably would not have 3-4 weeks ago. All of you, our dear guests, have addressed the Russian attack on Ukraine in one way or another. But one thing which I am wondering is that we are already seeing some of governments in the European Union member states try to use this opportunity to deflect criticism on the rule of law, sending a message that the rule of law is now not a problem because we have a far greater danger with the Russian attack on Ukraine and its consequences for the European Union, not just in terms of military danger, but in terms of millions of refugees who are fleeing to EU member states, primarily to Poland, but also to Hungary. And with many economic consequences of the war, the rule of law should now not be the focus for the European Union. Those politicians say that we need to focus on something else. And I would like maybe to hear a few words from each of our guests in the order as previously, Daniel first, Katalin second, and Kees third. How do you think we should tackle the attempts to, let's say, swipe the rule of law under the carpet and have it disappear from public discourse and have everyone focus on the war instead? Dear guests, what are your reflections? Daniel, starting with you.
My reflection is that we have inside the European Union people moving in the same direction as Vladimir Putin, using the same playbook. So saying we have actual Putin on our doorsteps with tanks, absolutely that is an issue that we need to deal with, but it should not mean that we allow people to move into the same direction inside the European Union. The European Union must be in a capacity to deal with more than one crisis at a time. And we have actually seen that in the case of Hungary. I mean, the developments are now 12 years old. And in a way, Orban has been saved time and again by different crises. You know, first it was the financial crisis that was more pressing than dealing with Orban. Then it was migration, then it was Brexit, then it was Corona, and now, you know, it's the war in Ukraine. And I think it's about time that we face Orban and his challenge to democracy and to the rule of law head on, because we see that these issues spread, and we see what in the late stage of things, what this can do. It's dictators start wars. So we cannot allow any autocratic tendencies inside the European Union.
Thank you, Daniel. Katalin, anything on that front from you?
Yes, thank you very much. Yes, we have another, except for the war, we have another issue in Hungary, which is the parliamentary elections, which take place on the 3rd of April. And I think this is in everybody's minds in Brussels, how to deal with Orban before the elections. Should we activate the conditionality mechanism? Should we accelerate the negotiations on the recovery plan, or should we wait until after the elections? I'm quite certain that the European Commission will not do anything before the elections, because of the elections, and also because of the war, which impacts Hungary as well as Poland quite heavily. But I'm quite certain that after the elections, and depending on the outcome of the elections, the European Commission cannot wait anymore with launching the rule of law conditionality mechanism, first and foremost because the European Parliament is pushing it for that, and if it doesn't want to lose credibility, it should act as soon as possible. Poland is another issue. There are rumors in Brussels that the recovery plan will be adopted by the European Commission soon. We don't know yet. The Commission doesn't say anything about that. But let's hope that it takes into account all the rule of law problems that have arisen in Poland also when decides about the recovery plan and also about the rule of law mechanism.
Thank you very much, Katalin. Kees, do you have any reflections?
Yes, two remarks. First, I think one of the unexpected effects of the war launched by Putin on Ukraine is the effect of a far closer cooperation in areas where we had little or only difficult cooperation within in the EU, and this will make the reliability among member states, the reliability that all EU member states are partners taking the rule of law serious, all the more urgent. The more the cooperation there will be in areas like defense or in areas like migration, there's all the more need for all member states complying with the basic rules. And the same you see, that's my second remark, in the area of on the issue of the large numbers of refugees. And I think the member states bordering on Ukraine are to be commended in the way that they deal with the refugee and the enormous numbers of refugee right now. But the facts that for the first time the temporary protection directive was put into force and are operated, the way that member states rely on each other and don't want to apply the Dublin rules. This is only possible if all member states play with the rules and not certain member states disregard rules that they don't like, whether it's rules in the temporary the protection directive or in other directives. We cannot, if we want to have a real close cooperation, we cannot have member states that just pick and choose which rules they like and which rules they disregard. And I think the present war in Ukraine only is an illustration of the need, the urgent need to keep the rule of law question on the table.
Thank you very much, Kees, and to all of our panelists. And I have now a couple of questions from the audience, and I will try to address them to the extent of time that we have available. And I will start with a question to Daniel. One rule of law tool that the European Union has in its arsenal, it's the Article 7 procedure, which is being carried out currently against Poland and Hungary, but we're not observing much movement on that matter. And the question is, do you have any ideas for proposals to change the proceedings on Article 7, especially given the highly politically charged nature of the Council, as opposed to more technical nature of other tools?
Well, indeed, on both those Article 7 procedures, I mean, they've been running since 2017 and 18 respectively. So 5 years in the case of Poland, 4 years in the case of Hungary. Nothing is happening, and we are not even seeing the Council moving towards the step before voting rights would actually be withheld. So even the 4/5 majority for the previous step currently doesn't seem to be in reach in the Council. I think basically that the Article 7 tool is broken. It can only be fixed through treaty change. So that needs unanimity among the member states, and Hungary and Poland are not going to allow that under their current governments. So I don't think there's anything really to be done on the Article 7 front. I think in any case that the money is the better lever for us. We have the conditionality mechanism. That's the bit we should be using. And we have seen where in the past couple of years, when the Commission, wherever they even loudly thought about financial consequences, we have seen Poland, or for example, in the case of the Polish regions that declared themselves LGBTIQ free, the Commission said, okay, but then no more EU funds. If then you're also EU fund free if you want to be LGBTIQ free. And the regions withdrew those declarations. So the financial lever works. That's the one that we should be using, and it requires a much lower threshold than unanimity of the others. It needs a qualified majority, and I think my hope is that qualified majority in the Council is there, but we only know when we eventually take that vote.
Thank you. And the next question I have, I think I will direct to Katalin, and the question refers to the conditionality mechanism. So what we know is that we have the judgments from the Court of Justice saying that the conditionality mechanism are all fine. We have also some rather worrying reports that the European Commission might hesitate and not trigger the rule of law conditionality mechanism due to the situation with the war, and especially with Poland taking in so many refugees. But I would like to maybe ask more specifically about Hungary. Do you believe that the rule of law conditionality mechanism has been so long worked on and discussed, and Daniel, who is with us, has been also the part of the team that's been pushing very strongly and negotiating for this mechanism. But in the particular context of Hungary, do you see this, from your perspective also as a journalist, do you see this mechanism going forward and having an actual effect in Hungary? Or is this something that Viktor Orban and his friends can brush off?
No, I think the conditionality mechanism will perfectly well work in Hungary, because basically this is an anti-corruption tool. And as Daniel and you also mentioned, corruption is prospering in Hungary during the Orbán government. So I think it will work perfectly well if the Commission decides to activate as soon as possible. We don't know how the events will proceeding after the elections. According to the latest polls, Orbán has still some advantages, so he might win. And then if it will the case, then I think the European Commission will have every reason to start the mechanism. It sent a very long letter, an informal letter to the government last year, at the end of last year, listing all the problems with the rule of law situation under the conditionality mechanism. So I am quite optimistic in the case of Hungary that it can be activated today if they want to.
Thank you. And maybe Daniel, as you've been also very heavily involved with the conditionality mechanism, what do you see the way forward, and how would you comment on the reports that the Commission might be reluctant to use the mechanism now that the EU member states are facing increased strain resulting from the effects of the war?
So, I mean, first of all, I would have triggered the rule of law conditionality on the 1st of January last year when it entered into force. We now have the ruling by the ECJ. Even those guidelines that the ECJ has said are not needed, the Commissioner has now adopted them. So really there's no excuse. And at some point, the Commission has sort of argued, yeah, well, but we need to put together this really solid legal case, because obviously any triggering of the conditionality, Poland and Hungary will sue against that again, so it will end up in the ECJ again. But I think, 15 months have been way more than enough time now to prepare that. And actually, together with John Moraine and two other law professors, we wrote the notification to the Hungarian government. We handed that over to the Commission last May, almost a year ago. So the work is done. No excuse there. I agree with Katalin. I think it's at this point very unlikely that something will happen before the election. I mean, basically what the Commission is then facing, that in the case of a re-election of Viktor Orbán, which is, it seems according to the polling at the moment, the more likely scenario, that means that shortly after the election, I would very much hope that then finally the Commission triggers the conditionality, but will then have to explain to everyone, look, we have this long list of rule of law violations that we have known about, some of them for years, but all of them definitely since before the election. But we as the Commission decided not to trigger this before the election, despite nowhere in the law it's saying this protects the rule of law, unless there's an election going on somewhere, then of course it doesn't apply. And the other scenario being that the opposition candidate wins the premiership, and then as a welcome gift to office, the Commission launches the rule of law conditionality, because obviously on election night or any time after, all those conditions why the rule of law conditionality needs to be triggered in Hungary, they remain the same, right? The opposition will not be able to fix any of that overnight. Some of these things are incredibly difficult to fix because they have either been enshrined in the constitution or they need a 2/3 majority in parliament to be altered, or they need new appointment to offices that have been appointed for years, sometimes for life by the current government. So yeah, both those are not great scenarios, and should have pointed towards having triggered that before the election. But I hope at least that this will happen soon. One thing that is still pending from the side of the parliament is that last summer, me and others got the parliament to adopt an inactivity lawsuit against the Commission. So this is Article 265, allows the institutions to sue each other when they don't do their job. And our feeling is that the Commission is not doing its job in terms of protecting the rule of law in the European Union. And I think we will hear on occasion from the European Court of Justice whether they agree with Parliament's assessment and will open hearings on the lawsuit.
Daniel, thank you very much. And there is another question which is building up directly on what you just said. So I'm going to throw this one also at you, and it's coming from a good friend, Jori Tavernier from the Dutch Helsinki Committee. And he asks, how can NGOs, with help and working with other member states and the European Parliament together, convince the Commission that now it is more important than ever to defend the rule of law in the EU and to trigger this mechanism? What sort of guidance for especially NGOs, as Jori is together with me part of the WARE program, a group of NGOs working together on the rule of law. What advice would you have for the civil society to act in this situation?
I would actually encourage civil society not to focus too much on the Commission, but to work with their respective governments of the member states, because the reason that the Commission is reluctant is that they have the impression that they don't have the member states behind this, right? And indeed, the European heads of state discussed the situation in Hungary for the first time last year. You know, after everything that had happened, after all those attacks for over 10 years on the judiciary, on media, the widespread corruption, the heads of state had never discussed it. It was only when Orban passed that LGBTI law that for the first time they even discussed it. And I think NGOs everywhere in Europe should really pressure their governments into doing something about it, speaking up, and that the governments signal very clearly to the Commission, look, we want the rule of law conditionality to be triggered. We want our taxpayer money to be protected. We want the European rule of law to be protected. That's the message that should be going to every government. I have to say that in the Netherlands, I find the situation reasonably hopeful, right? There's a lot of pressure from the parliament. The government has spoken out in the past on these issues, but most governments of member states have been silent on these issues. And particularly, I would say one key country at the moment, obviously, is France. They hold the rotating presidency. One would think that Emmanuel Macron is a staunch defender of liberal democracy and you know, the rule of law, but his government has not been putting a lot of pressure on these on these issues in the past. I mean, I have hopefully contributed a little bit in getting a new German government in place that has a very different line on these things than the previous Merkel-led government. But you know, we need a qualified majority at the end, and when there is pressure from the governments, then this question will really move forward.
Thank you very much. And before I turn to likely the last question today, I would like to remind everyone that we have put the link to event evaluation form in the chat, and we would be very thankful if you could take all a moment after our event to fill this survey and to let us know what you think about our event so that we can improve in the future. And the question now that I want to turn, I'm probably going to turn it over to Kees, who has some bird's eye view on where EU is positioned, is the question of what actually can the European Union do about the rule of law situation, not in its member states, but in countries that are closely associated or candidates to the European Union. For example, as the question from Ms. Zahojarski is, Serbia, and what can the EU practically do about the rule of law issues in candidate countries?
Yes, a good question, and it illustrates the relevance of the rule of law in the face of the accession of new member states, where there is a clear catalogue of criteria to become a member state called the Copenhagen criteria, where the rule of law is one of the central elements. And there is a procedure of very detailed, on the one hand, support to improve the legislation and the practice in candidate member states in this field, and on the other hand, regularly monitoring whether there is sufficient change in the practice in member states, and there's to my knowledge also money available for EU money available for NGOs to support this development in member states. I mean, it's one of the arguments, one of the arguments used right now to those who oppose candidate membership for Ukraine right now, that the rule of law requirements of the EU are so high that Ukraine won't be able to meet them, and that is then used as an argument not to grant Ukraine the status of candidate membership. The implicit point in the EU system is that rule of law is not only relevant on the moment of accession, but continues to be relevant also after, once you are a member state.
Thank you very much, Kees. And this is indeed always an interesting question about the European Union setting a very high bar to join when it comes to rule of law, democracy, and human rights. But then after you join the European Union, their tools to enforce the rule of law and protect democracy and rule of and human rights in member states are frequently, as we can see recently, not up to task, and the EU is now playing a little bit of a catch-up game with introducing new mechanisms such as the rule of law conditionality to fill this void. Unfortunately, we are running close to our end time, so I would like now to thank very much our distinguished guests for joining us and for answering the questions. And I think it has been a very lively discussion about the rule of law in the European Union. We'd like to encourage everyone to go to our website, look at the rule of law frequently asked question cards, download them, and use them in your everyday work and interaction on the rule of law. And we hope you find it useful. We will be looking into perhaps expanding this tool and building up upon this. As you know, Poland and Hungary are, of course, the two most often discussed countries when it comes to the rule of law, but there are multiple other EU member states where the rule of law is an issue to one degree or another, and which also warrant a help for discussing the rule of law there. So once again, I would like to thank you all very much. I would like to invite you to follow Committee Meijers and Democracy Reporting International and our work on the rule of law in European Union and beyond. And I hope that I will be seeing you all soon at another one of our events. Thank you very much.